Well, hello and welcome to week 9. So this week we'll cover the time-tested topics of negligence and intentional torts. So what's a tort? So torts subject people and organization to civil liability versus criminal liability. So the tort relates to what somebody did not do correctly, and because of that, a person is harmed. So the basic principles of tort liability and common defense will be explained in this chapter. So in addition, there are numerous examples of how medical malpractice suits are applied in the courts, including key decisions that established important legal precedents. So the principles covered are firmly established in our legal system. The basic elements for negligence, which is the legal theory supporting most medical malpractice, will be covered. So in the vast majority of cases, malpractice cases are settled by the parties' insurance companies. So the legal lessons learned in these cases typically aren't published. So they're these court decisions. So the outcome of most litigated cases reported in state court decisions typically depend on expert testimony, which means that you have an qualified expert witness, and it's usually like a medical professional who provides the testimony needed for like one side to prevail. So the 4 elements of a negligence claim are duty, breach of duty. The breach of duty, legal duty, is the proximate cause of harm to the plaintiff, and the plaintiff suffers damages. So some state courts vary slightly in their description of these elements, but for the most part, state law concepts and definitions of negligence are really very similar. So the basic understanding of liability principles can help minimize claims and organize liability coverage and facilitate proper handling of asserted claims. So as students, you should understand that hospitals work really hard, and I'm sure you're aware of this, to design and maintain a comprehensive risk management program. The primary focus of risk management programs is on risk associated with the primary focus of risk management is on risks associated with negligent conduct. So it's not always about medical treatments. So I know when I worked at my former job, I was in compliance and regulatory stuff, and I worked with risk management. And a lot of times they would have people report, like if somebody slipped on some water in the hallway or something happened. So it wasn't always like something against a doctor, but anyway, I digress. All right, so arbitration is used in many business settings due to the expense, delay, and potential negative publicity associated with public litigation. So often employment managed care, and other business contracts include provisions that bind the parties to arbitrate contractual disputes. It's a lot more efficient, I think. Anyway, so we're going to review negligence principles and intentional torts, and it's helpful to remember that intentional torts differ from negligence primarily because expert testimony is rarely required. So we'll also review the major defenses to tort actions, and we'll look at statutes of limitation, which are an important defense and vary state to state. And we'll also cover the principles of strict liability and product liability suits. And that's actually pretty interesting because we look at like blood transfusions and drugs and other things, medical devices. Let's see, principles of strict liability and product liability suits, I just said that. We'll also address who's responsible for payment of damages, and we'll also address insurance coverage for torts. And finally, at the end of the chapter, there are a bunch of examples that are kind of interesting. So I hope that you enjoy this week's topic. I think it's going to be a good one. And speaking for myself, I find every week there's stuff, and I think, wow, when I was working in the lab, I was aware of these things, but I didn't really give it a lot of thought. So it's cool to really kind of dive into it and look at it a little deeper. So have a great week, and see you in class.